We are going to shift gears a little bit for our next panel. We've spent the morning so far talking about setting up corporate structure, financing issues, working with host towns. Now we're going to talk about managing cannabis in the workplace. Today we have from McLane Middleton, two attorneys. Our first panelist is Adam Hamill. Adam is a director in McLane Middleton's litigation department, vice chair of the firm's employment law practice group. He concentrates his practice in areas of business, employment, and probate litigation, and regularly assists clients on a variety of commercial and employment litigation matters, including claims of wrongful termination, discrimination, and violations of restrictive covenants. Joining him is Susan Shore of counsel at McLane Middleton. Susan finds solutions to legal questions and challenges faced by independent schools and social services organizations and manages investigations when serious misconduct is alleged. And they are going to talk both about cannabis in the workplace and cannabis on school campuses. I'm going to turn it over to them.
Thank you very much. So yeah, as Susan said, Susan Shore and I are with McLane Middleton. We're a regional law firm based with offices in New Hampshire and Massachusetts. We primarily serve small, mid-sized companies, as well as we have a very good-sized independent school practice. And so one of the things that we've been dealing a lot with our clients on as more and more states are legalizing marijuana, both for medical and recreational use, is sort of the impacts that is having on employers when their employees are starting to use medical and recreational marijuana, mostly off-duty, as well as students and teachers at independent schools as well. So we're going to spend some time today talking a little bit about sort of the development of those laws and sort of the impacts that's been having on employers.
So I don't know if I certainly found the panels this morning very informative, since that's not really the focus of my practice, but I think we're really here to talk about on the off chance that folks get through all the hurdles to actually establish a place where people can purchase cannabis and marijuana, and they're using it, hopefully appropriately. We're really here to talk about, the impacts that might have on employers. So are we on our agenda slide? So we are first going to just do and we also understand this is a pretty sophisticated audience in terms of your knowledge of marijuana. So we're going to do a pretty high-level overview of medical marijuana, but that does have important implications for employment in terms of accommodations. Then we'll talk more about recreational use, drug testing and employees. Again, that's going to be an area where we receive a lot of questions from our clients in terms of whether or not they should be doing drug testing in the first place, and if they are, how to structure that kind of program. And then my particular practice is a focus on independent schools, K through 12 private schools, some higher ed. So we'll finish out with just a few sort of extra implications that schools, who are obviously also employers, but have students to consider as well, so some things that may be relevant for them.
So there's a long history in Massachusetts of regulating marijuana. It goes back more than 100 years. Massachusetts was actually one of the first states in the country to actually get into the fray. It was a law in 1911 that outlawed marijuana, and then the federal government began regulating it in the 1930s. And so the path to legalization and where we are now is actually relatively new news. I mean, we started back in 2008 with steps to sort of begin to decriminalize marijuana, and then it was in the after 2012 that things started moving a little bit more quickly with the voter referendums to legalize marijuana for medical use, and then following on those heels, the recent enactment again on a voter referendum of legalizing marijuana for recreational use. So these changes over the last decade or so have really presented some interesting challenges for employers, and employers are doing the best they can to try to adjust to these. And sort of there's competing, and we'll talk a bit about this. Competing challenges they're facing. When we're talking about both state law, federal law, and how those things intersect, and raises some really interesting questions and challenges for employers. So before we get into some of those things, we thought it might be helpful to kind of give, as Susan said, sort of a high-level overview of kind of what the state of the law is on these areas, and we probably won't go too much into the weeds, but thought it'd be helpful to have a didn't mean to make a pun there actually, but to kind of sort of give us a little bit of an overview.
Right, so of course, I think most people know before the recreational use was approved here in Massachusetts, we started off with approval of medical marijuana. So that went into effect by a pretty healthy margin of the voters in 2012, or went into effect in 2013. And Adam and I have done this presentation a few months ago, and as I think everyone in the room is aware, I mean, the numbers up here in terms of the rough number of registered medical marijuana dispensaries at about 50, with about 60,000 patients who are actively registered to use. You know, these numbers obviously change almost daily, and they certainly have jumped up in the past, I don't know, 6 months or so since we last did a presentation on this. So that continues to be, you know, an important market, if you will, for marijuana, medical marijuana. I think, oops, sorry, did I skip a? Okay, right, here we go. All right, so the overview in terms of medical, again, I think as most people know, you need to be approved by a physician in order to get a medical marijuana registration, and are limited to a 60-day supply of whatever the product is, the form of the product is that you're going to be using to help combat the symptoms that you may be experiencing. And to go to what are those qualifying patient conditions, it's really a pretty, you know, limited number of very serious illnesses that generally have associated with them, you know, serious pain or debilitating conditions. And, you know, there are definitions of what that means. So the point being that, you know, it's, you need to jump through some pretty serious hurdles and have some pretty serious health problems in order to qualify, legitimately qualify for the use. I was just at a talk at Beth Israel Deaconess earlier in the week about the opioid crisis, and while there's obviously, you know, I use this analogy very, very, very loosely, since cannabis and opioids are obviously very different, but one question that has come up a lot in our practice when our clients ask us about having employees who may be using medical marijuana, you know, are they high? You know, are they somehow impacted? And my understanding is, obviously I'm not a doctor, but, you know, people use medical marijuana and, you know, legitimate use of opioids is to treat pain. They're in serious pain, and this is a drug that helps alleviate that pain. There are certainly some people, you know, outliers who will also experience some sort of a psychoactive high, but that's really not the purpose of the use of medical marijuana. Someone at the talk earlier in the week, a cancer doctor said, you know, it's really not my population of patients who are abusing, whether it's, you know, cannabis or opioids. There's very little abuse in terms of people who are legitimately using medical marijuana. So I just wanted to make that point.
So then the next question then is, you know, is accommodation. What is it that, you know, that employers are required to do? And the one thing I would say, you know, off the bat is that, you know, both in the realm of medical and recreational marijuana, there is nothing in the law that under any circumstances requires an employer to permit employees to either be under the influence of marijuana or to be possessing marijuana in the workplace. So, you know, sort of that, you know, in the workplace, active use or possession of marijuana that is not provided for by the law. There's been no, you know, case law that indicates that, you know, an employee has a right to be either under the influence or in possession of marijuana in the workplace. Really, where the issues are coming up and where the questions that we're facing is, what about people's off-duty use of either medical or recreational marijuana? And that's really where the big challenges come up. We look to the statute itself, and what the statute says, and this is the medical marijuana statute, says this chapter shall not require an employer to permit or accommodate conduct otherwise allowed by this chapter in the workplace, and shall not affect the authority of employers to enact and enforce workplace policies restricting the consumption of marijuana by employees. And what I would highlight in that language is the word in the workplace. And that's sort of the sentence that I basically said. So, when this law first came out, part of what, I was sort of naively thinking, well, this is fine because, this still protects employers to be able to have, sort of these, drug-free workplace policies and, and continue on doing their drug testing. But, as we know, there's been some case law that has changed that, and that's the next thing that I'll talk about, and that is the Barbudo case that was decided by the SJC in 2017. And this was an interesting case involving a woman who was working for a company, was sort of these marketing companies, what the companies that provide samples in grocery stores, those product samples. And so she applied for a job as one of these people who was going to be providing samples, and she was told at the outset of the application process, oh, by the way, we have a pre-employment drug testing policy. And she was upfront with the hiring manager and said, I'm going to fail that test because I have Crohn's disease, and as part of that, I have a medical certificate, and I use marijuana, but I don't use it very often, and I'm never going to use it at work. And the hiring manager told her, oh, that won't be a problem. Don't worry about it. And so she was offered a job. She accepted the job, and as part of her onboarding, she took the drug testing, and of course, as she predicted, she failed the test. So after her first day of work, the human resources director called her up and said, well, we follow federal law here, and federal law says that marijuana is illegal, so I'm sorry, but we're going to have to fire you. And so then, she brought suit, and she brought it under a number of different legal theories, including invasion of privacy, under the language in the statute, et cetera, and also under Chapter 151 A or 151B, which is the anti-discrimination statute here in Massachusetts. And so what the SJC decided in that case is that, that it is, that an employer may not have sort of a blanket policy that says, that we are not going to accommodate someone's off-duty use of medical marijuana. What the SJC said in the Barbudo case is that, you have to at least be open to the possibility and consider that the off-duty use of medical marijuana is going to be a reasonable accommodation. So in the same way that under, whether you fall under, 151B or the ADA, any kind of accommodation for any kind of disability, you have to engage in what's called the interactive process with the employee, and that is basically, talking about, what are the requirements of the job, what is it that the employee, can and can do, are there reasonable accommodations that the employee, that can be made to allow that employee to perform the required functions of the job. And so, if it is the case that an accommodation that is asked for imposes an unreasonable burden on the employer, then, both under state and federal law, the employer is not required to make that accommodation for the employee. And so, what the SJC decided in Barbudo is not necessarily that, accommodating someone's off-duty use of medical marijuana is always going to be a reasonable accommodation. There may be circumstances where, because of, let's say that the employer is bound by, Department of Transportation drug testing requirements, and so, it is going to be an unreasonable requirement for us, because of the job duties of this job, to be able to, meet that business requirement that we have and accommodate this employee on the other hand. So going through that analysis, maybe under those circumstances, yes, that would not be a reasonable accommodation, and it would be okay to either refuse to hire that employee or terminate them. But, what the Barbudo case is saying is that we can't have sort of these, blanket policies that, under no circumstances are we going to ever accommodate medical marijuana. The MCAD, which is the state agency that is in charge of, in the first instance, looking at anti-discrimination or discrimination claims in Massachusetts, and they, are sort of charged with enforcing 151B. They have got, they've taken a position on this, and that position is that, and it's very in line with what the SJC ruled in Barbudo, and their position is that the termination of an individual's employment based on the lawful use of medical marijuana outside of the workplace, or the failure to even consider the off-site use of medical marijuana as an accommodation that permits an individual with a disability to work, may violate Chapter 151B. And so, as is typically the case, with administrative agencies and the MCAD in particular, the courts do, give some deference and, and rely on the MCAD in terms of how they interpret the law that they enforced. So, this interpretation, while it in and of itself is not binding law, is definitely, instructive for employers and how to deal with these issues. So again, the takeaway is that, under the current law, it is probably not permissible for an employer to terminate or refuse to hire an employee solely on the basis that, that they engage in the off-duty use of medical marijuana. There's sort of the additional steps and considerations that you have to take before you could, go that route. Another sort of interesting wrinkle on this is, is with regard to workers' comp. And so, for instance, you've got an employee who is on workers' comp, and for instance, is the workers' comp carrier, going to be, is their medical marijuana, is it covered by workers' comp? The expense for that. There was a decision by the Department of Industrial Accidents that said that an employer, the carrier, cannot, under Massachusetts law, be forced to pay for medical marijuana. However, interestingly enough, the Supreme Court in New Hampshire came down on the exact opposite end of that rule. So, this is an issue that has not been addressed by either the appeals court or the SJC. So, interesting to see, what will happen if that issue comes up. Just sort of another, wrinkle in this in terms of, the interplay between, employees on disability or workers' comp, and and whether or not medical marijuana could be part of a treatment for a employment-based injury. And this is where we get into the issue of the interplay and the real conflict between state and federal law on this issue. What about federal contractors? So I mean, if I'm an employer that really just deals, in state law, all I'm worried about is that, Barbudo, it's challenging, it's difficult, but that's all I need to worry about. But if you overlay on that, if you're an employer who is either a federal contractor or subject to some federal regulations and laws, you've got some special headaches that you need to deal with. And so, because obviously, as we've heard all day today, and we know that marijuana is a Schedule I illegal drug under the Controlled Substances Act. And so employers who are federal contractors are bound by the Drug-Free Workplace Act. And so, and that requires that any employer, any company that receives at least, $100,000, they're required to have a drug-free workplace policy as well as a drug-free awareness program. So, and that companies who violate the Drug-Free Workplace Act run the risk of having their federal contracts terminated. So this is obviously something that is, a very important issue to employers who are federal contractors. And an interesting sort of, illustration of this, and, where people can, get tripped up and people are looking at this, is that a few months ago, back in the spring, Elon Musk, who, is a federal contractor with his SpaceX program and things like that, he was, on Twitter and this web video, him and Joe Rogan were, doing this interview where, during the video, Elon Musk, consumed marijuana. And so federal regulators started saying, is this something we need to be looking at? So that was a headache that he had. So, this is a real issue that employers who are federal contractors are going to need to be dealing with. But again, the issue is not an easy one. You can't just say, okay, well, fine, I'm a federal contractor and I am subject to the Drug-Free Workplace Act, and so therefore, I can just say I've got this blanket rule. Not necessarily. There was a federal court case, I believe it was at the district court level, not an appeals court case, that was handed down in September of 2018, and that case, I think, is unfortunately, puts employers in a tough spot, because what that case said is that, that the employer wrongfully relied on the federal law to fire an employee for off-duty use of medical marijuana. What the court said is that, yeah, even though you are bound by the Drug-Free Workplace Act, that law does not require you to affirmatively, engage in drug testing, and does not require you to refuse to hire workers who use marijuana away from work. So, this is a double-edged sword for employers who are also federal contractors or who are otherwise subject to this law, because on the one hand, you're bound by the law, but, if other courts, follow the lead of this Connecticut U.S. District Court case, you might not necessarily be able to, rely on that as a shield to protect you from, taking hardline rules. So, I think that unfortunately there are no easy answers for employers who are stuck in the crosshairs of the federal-state conflict here. And what we unfortunately really need is, some action and some clarity on the federal level. We don't really know what's going to happen here. I mean, the current Attorney General, Bill Barr, is not as sort of strident as, the former Attorney General was. Jeff Sessions was a real sort of crusader with regard to, anti-pot and sort of, enforcing that. I think that the Department of Justice has, perhaps moved on to some other issues. But, like I said, again, until there's some real clarity here, so we're looking at, are there some, potential legislative fixes? And there is some legislation, pending at the federal level in Congress that might deal with this. So, I mean, there was an act that was passed by the House in March called the Fairness in Federal Drug Testing under State Laws Act, which would provide some protection to federal employees of the federal government who are, legally using marijuana under the law of the state where they reside. And there was also another vote that was made by the U.S. House of Representatives recently to prohibit the Justice Department for interfering with state marijuana laws. So, I mean, there is movement in Congress, but the problem that we have is, that even though the House is taking action, the House and the Senate aren't really, playing nicely together these days. And so the question will be, whether or not these initiatives in the House will, actually, make it through the Senate and to the President's desk. There is some legislation that is pending in in Massachusetts on this. And next slide. There's at least there's a whole slew of bills that are currently pending in the state legislature, and at least 4 of them that I count, at least 4 of them touch on employee rights and on marijuana in the workplace. The first of those is Senate Bill 978, and this is a bill that would prevent employers from taking adverse employment action for the off-duty use of marijuana. The next one is House Bill 3537, and this would prevent employers from taking adverse employment action based on a positive marijuana test unless there is probable cause that the employee is impaired at work. So basically, kind of what that law, if it's passed, would do is essentially kind of, protect people from sort of pre-employment drug testing, as well as, it would have to be sort of a reasonable suspicion based. The House Bill 3538 is one that would sort of specify that employees will not lose their rights under state law, specifically 151B, because of the use of medical marijuana. And I think this act or bill is really sort of in direct response to one of the arguments that the court considered in the Barbudo case. And there was some question about whether or not, how those two laws interacted. And I think that, that this bill, if it was passed, would sort of eliminate any confusion that, an employee who is using medical marijuana would not lose their rights under the anti-discrimination statute and be protected under that. And then finally, House Bill 3751, this is when it would be a little bit more sweeping. If it were passed, it would prohibit employment-based testing for marijuana except if required by federal law or other state law. So that would, I think, is probably the most expansive one. And that one, as I said, if passed, would really essentially kind of eliminate pre-employment testing for marijuana. All of these laws are currently in committee, in the state legislature. So, who knows what will happen to them? But I think that the clear message here is that, that this is something that is, very active in the state legislature. In addition to these 4 employment-related marijuana laws, there's a special committee in the legislature that is considering, like I said, a whole list of marijuana-related legislation.
Okay, and just wrapping up on the sort of accommodations piece of what we wanted to talk to you about, under the Americans with Disabilities Act, which is federal law, that will apply to most employers unless you're a really small business. So it really is something to pay attention to in terms of how alcohol and marijuana are treated somewhat similarly, but also not identically under the ADA. So someone with an alcohol use problem is considered to have a disability under the ADA, and so is entitled to some protections and accommodations. But the problem, going back to marijuana, still being a Schedule I drug under federal law and therefore an illegal drug, the focus is really on if someone is actively using that drug, even potentially, legitimately, medical marijuana off-site use, that kind of thing. Under the ADA, the requirements for accommodations are not quite as sympathetic, shall we say, as they are for someone who has a problem with alcohol. So again, just something to think about in terms of this accommodations universe. And then finally, wouldn't be complete without a little mention of CBD, or I say cannabidiol, but I'm not sure if that's the right way to pronounce it. So we get a lot of questions about CBD, which I think, as most people in the room would know, is not supposed to be psychoactive, and therefore, what's the problem if anybody's using it? I think lots of literature about the benefits of CBD, everything from helping sleep to treating anxiety to treating pain, but there is only one FDA-approved drug right now, which is meant to treat a very sort of narrow form of epilepsy that's actually been approved. So the problem is that CBD isn't a regulated substance at this point, so you don't really know what you're getting if you're using CBD. So there are risks. We'll talk more about the drug testing piece, but if someone is, sort of in good faith consuming CBD, let's say to help them sleep, and they work for an employer who does drug testing, and they come up with a positive drug screen for THC, for example, there's no way to prove, other than their word, that they have not consumed THC. And frankly, they may unwittingly have consumed THC if they're using a CBD product that contains, more than the trace amounts of CBD. So that's one area where employees who use CBD can get into trouble. I did have a school ask me, it was last spring, a student, high school age student, this is a day school in the Boston area, apparently wanted to be using CBD. And so I said, okay, well, at least as a threshold here, thinking of Barbudo and this interactive process, let's at least try to get a note from the doctor about, why is the student needing to use CBD? And the healthcare provider wouldn't provide that note. And so so we kind of left it, okay, this is a day school. It was easy enough to just say, you know what, let's not be using that product while we're at school. Who knows what the student will be doing at home? But I thought it was kind of interesting that, a physician wasn't willing to put pen to paper and say there was a legitimate reason why the student needed to use CBD. So the other thing that's come up for me recently, we're obviously in the back-to-school season now, and if they weren't doing it in August, they're still last-minute. Schools are trying to get their employee handbooks and their student and parent handbooks up to speed, and I've just in the last week gotten a couple of questions from different schools. What do we do about CBD? So I think we're making sure to tell our schools in the section in the handbook that addresses drug and alcohol use and tobacco use and now nicotine use, right, with Juuls and all of that, to make sure that you're explicitly making a reference to CBD and indicating, because it's, it's no way to tell unless you're sending it off to a lab what's in it. You are really discouraging the use of that substance, again, for both employees and for students on campus. So we're off medical marijuana now and into the recreational use world. And again, as everyone knows, by a bit more narrow margin from medical marijuana, we are now, what this morning has been all about, right, establishing ability for people to purchase cannabis legally. So I think I heard the number 24 earlier this morning. By my count, we were up to 26 locations where you can now legally purchase marijuana. And again, just to sort of quick overview in terms of the permitted use, this certainly has implications for when I talk about schools. You know, must be over the age of 21, and there's, you know, small amounts that you're actually able to possess a little bit more in the home, ability to grow the 6 plants. Massachusetts allows adults to give but not sell up to an ounce to another adult. This is another area that I think may be up for discussion in terms of you know, using marijuana and driving a vehicle, for example, right? How do you tell if someone is actually impaired? So it is still illegal to operate under the influence. And in theory, still illegal to operate, to consume in public. And I will say our office, our Boston office is, you know, literally around the corner from here in the old Boston City Hall building, and I live in the South End, so I'm lucky enough to be able to walk to work, walk that 20-minute, and when I go home every night on that stretch of Tremont Street by the Park Street subway station, boy, oh boy, you know, the contact high or whatever, but I don't think everybody is paying attention to this last point, is all I will say. And, you know, it's obviously right around here, Suffolk, so.
So the question now becomes, and this is one of the sort of the real kind of hot button topics for, you know, now that this is, you know, legal in Massachusetts, even, you know, it was, you know, especially for recreational use, you know, what are employers going to do about drug testing? You know, 10 years ago, you know, people who wanted to have drug testing programs, you know, it was fairly easy to do, and, you know, you test people for marijuana, and that was part of your whole protocol. There were no worries about it. But now that we have, you know, a whole, you know, group of people who are using marijuana, both, you know, for medical and now legally for recreational purposes off duty, what are employers going to do with regard to drug testing? And the real big problem here, I think, is, as I mentioned before, you know, how in resolving the conflict between state and federal law, we really need some action in the federal law. I think to help employers with this issue, and also this is, you know, an issue that's been raised by law enforcement as well, is that, you know, we really need science to come up with a way to create a drug test that will determine if someone is actually currently under the influence of marijuana. Because, of course, you know, the testing that is available today, you know, it won't necessarily tell you if someone is high right now, but it will tell you, you know, did they consume marijuana anytime within the last, you know, day, week, sometimes even month, depending upon, you know, the test and upon, you know, the frequency of use that the person is involved in. So, you know, and this is raising problems because, of course, you know, just any drug test could, you know, bring in an employee who is, you know, legally using marijuana outside of the workplace. And so there's been a ton of coverage in the news lately about this issue. I mean, you can see that, you know, these are some headlines that I pulled out of the Globe from the last year, you know, that talking about how employers are grappling with the drug testing, and that employers, you know, are sort of, you know, a little bit of a pun here, mellowing out on drug testing because, you know, a lot of employers are beginning to sense that, you know, it's just not worth it to test for marijuana. And then there's also an interesting piece of it in terms of, you know, from a public and employee relations point of view. So there's been a couple of interesting, you know, kind of, you know, sympathetic stories that the Globe has latched onto over the last year. Both of them involved employees of Sodexo, a company that provides a bunch of different things, including food services to hospitals. And so one of the stories involved a woman who was a managerial employee in the food services department at Holy Family Hospital in Methuen. And, you know, she was walking down the hallway, and gosh, like everybody does every now and then, you get clumsy, and her feet got tangled up, and she tripped and fell, hurt her arm. She said, "Oh gosh, that really hurt." But, you know, really, at the first, you know, her she was really, she thought she had just really hurt her pride. But, you know, she went home over the long holiday weekend, and when she, you know, on Monday, she goes, "Gosh, my arm still really hurts." And she realized she actually had broken her arm. And so, you know, she comes back to work on Monday, and, you know, and she gets some medical treatment, realizes there's a fracture. And so then, you know, she obviously puts in a workers' comp, you know, an incident report. And as part of the policy for Sodexo as well, you know, any employee, you know, work-related injury, accident, you got to get a drug test. And so, you know, here's the problem with this woman is that she was legally on the weekends at night, every now and then, she'd like to take a few puffs of her, of her vape pen and play video games to relax and unwind. And wouldn't you know that even, in between her accident on whatever it was, Thursday or Friday, and then this long weekend, when she gets to work on Monday and, and actually realizes she had broken her arm during that long holiday weekend, well, she had a few puffs of her pen. But, her position is, I wasn't under the influence, when the accident happened, and nothing happened. But, so she had to take this drug test, was taken days after the incident occurred. And of course, it came back positive, and under the company's policy, she was terminated. And so, her coworkers, were in some ways kind of outraged by this. Here's this woman who, by all accounts, was a model employee. People really enjoyed working for her, and they felt it was pretty unfair that she was pulled into this situation. A very similar situation happened to a cafeteria worker at a lab at MIT. The guy just, nicked himself with a knife, and from, the way it's described in the Globe story, it was a really minor cut. But again, sort of the company policy was you take a drug test, and he failed it. And again, the researchers at MIT tried to put in a good word for this guy, but the company policy says this is what it was. And this gentleman, he was close to retirement, and he's not going to get his pension now. And these are tough issues for employers, but at the same time, from the employer's point of view, especially the person dealing with knives, heavy equipment, or other types of jobs, you can think about people who are in safety sensitive positions. What's the employer to do, about to have, your drug testing policy?
All right, so the shame issue is what makes me the craziest. So people use cannabis like alcohol now. It's legal. You're putting people, these employers have policies. And what are the policies based on? They aren't usually based on anything. So this is where the fight is. I find that frustrating that these are policies in place for whatever reason. These situations come up, and then there's no there
Right.
for why the policy exists.
Yeah.
We're just sort of going along, and that continues to shame, which shouldn't exist.
And you make an excellent point, and I think that I think that what people are predicting, and it's just a matter of having both science and culture catch up with this. But I think that I don't know how soon it's going to happen, but eventually off-duty use of recreational marijuana is going to be viewed in the same way that we currently view the off-duty use of alcohol. It's just a matter of how quickly can that happen, so that these issues, and until that happens, what are employers to do, and how are they going to deal with these issues? Because really, I think that that's ultimately where we're gonna end up.
It's simply unraveling the policy that was put in place for very bad reasons usually. So this is based on bad science. Why cannabis sits as a controlled substance act. That's the truth of it. So that's my point.
Sure.
So I think in certain circumstances, yeah, there could be not a reason behind the policy, but for example, on the municipal side, you have public safety, you have your DOT licensed workers, and the risk that a municipality faces is that one of these employees could be in a critical incident and suddenly test positive, even if they weren't impaired at the time, because the science isn't caught up with it, the municipality faces a significant risk. So it is a science issue that we have to kind of wrap our arms around.
I mean, I'd be interested whether or not there were any cases out there that have actually tied the impairment under marijuana to negligence or causation with respect to some accident or something that happened. Someone cut themselves or cut someone else. Have there been any cases that you're aware of?
Not that I'm aware of, where I mean, and that obviously, would be, and part of that problem is that, under, as I understand it, under the current, medical testing, lab testing available, you wouldn't be able to prove that. You would have, the facts would have to be such that, there would have to be someone witnessing, I saw my coworker or the manager said, the the person was on their lunch break, and I saw them out in the parking lot, you know, smoking a joint, and then they came into work and they crashed the forklift in the warehouse. You know, so I mean, if you had those facts, that would be an easy one. But if it's just, you know, this employee had an accident, we sent them to the lab for a drug test, it came back positive, you know, how would you be able to, you know, to make that causal connection? That's the tough part. And I think to your point, ma'am, that, you know, this is where, you know, it was very easy. We've got a drug-free workplace, and, you know, in so we test everybody pre-employment, even if the person is, you know, handing out samples of Swedish meatballs at the grocery store, like, you know, Ms. Barbuto was when, you know, and I obviously don't know all the facts of that case, and I'm not going to, you know, criticize that employer, but I mean, you know, why do we care whether or not that person is using marijuana? But at the same time, you know, if someone is, you know, driving, you know, a piggyback, you know, double-decker, you know, tractor-trailer, I might have a little bit of a different view about
That's an
that.
issue of, like, you know, someone who you're anticipating a problem because you have a misconception of what cannabis use is versus someone who does something. You know, I've worked for jobs where I know someone's high and there's been an issue and I've had to have them tested.
Yeah.
That's a different situation than this pre-assumption that anyone who has it in your system at any moment, at any time, cannot be employed. That's a different assumption.
The way the policies are gets,
To address what she just said, she knows people that are high and has to get them tested. There's still no proof that they were actually high at the time that you were talking to them. You have there's no physical test known right now that you can actually test for an individual to find out whether or not they're under the impairment of THC. So until that point in time comes, you're gonna have these issues because there's a liability standpoint. If you wanna get on a plane with a pilot, I don't care that he smoked last week, I don't want him smoking, period. I mean, so there's certain elements of society that, yeah, they should be subject to drug tests.
You not want them ever
Military,
drinking
the
though?
law
That's a whole
enforcement,
nother, I don't know.
firefighters.
You never want them to drink?
I don't want to come to work drunk, but I can tell you what, I've actually sent troopers to take a breathalyzer test as they came in because they had smelled of alcohol. And we were able to do something
But
about it.
the point is
and
that, do you
prevent
want them
from
never to
working.
ever be able to
Marijuana.
drink ever, or do you want them, that's the point of cannabis, is that you
Right.
never want anyone to ever be
No,
able to
until
consume.
you can
Until you
prove that
prove
they are
it.
not under the influence at the time. And that's the point with the employers. I mean, it's a liability aspect of
I
the
understand
employers.
that, yeah.
So that's, look, I'm all for it. You wanna do what you wanna do on your off time, but there's certain positions that you need to be able to articulate that can't do this. And until you have a testing mechanism in place to prove, like a breathalyzer, you don't have the ability to tell employers that they can't, because it's a liability. You put somebody in and they get hurt, or they hurt somebody, well, why didn't you drug test them? I did, they got positive for marijuana, well, I have no idea when. So it's not gonna settle itself out until you have the technology to deal with it.
And another issue that we haven't talked about yet is, you know, that in terms of, you know, another issue that is causing employers some angst about whether or not to, you know, to test for marijuana at all is that, you know, we're currently in an economy where we have very, very low unemployment, and, you know, and employers are constantly telling us and each other and things, you know, I can't hire people, I can't fill my third shift if I'm gonna do drug testing because, you know, all of my applicants are going to fail. And so, you know, employers are saying, you know, that I'm going to stop testing for marijuana because, you know, I'm sort of, you know, preventing myself from filling jobs. And so, you know, if the economy took a turn, if things were different, unemployment rates were different, that would not be a concern. But that's just an additional issue that employers are facing. So I don't really want to spend I'm just going to go pretty quickly through, you know, a little very, very high level overview of kind of, you know, some, you know, drug testing protocols. I'm going to really kind of whiz through this because I don't really want this to be sort of a how-to on how to do drug testing, but just to, you know, sort of give a high level overview of that. So, you know, in terms of, you know, drug and alcohol policies in general, you know, what employers, you know, should do is that the policy needs obviously to be, clear and in writing, provided to employees well in advance, part of your employee handbook, and if you can do training on it, that's great too. Because people need to know, what the rules of the game are, in advance and understand what's going to happen. So, that there needs to be a clear statement about what the testing protocols are going to be and what the circumstances under which testing is going to be done. Employees need to understand that, participation in drug testing is a condition of employment. So, if an employee is going to refuse to take a drug test that is legitimately being, asked to do, then that refusal is going to be a grounds for termination. And so, and again, employees and applicants need to know up front, what's going to be expected of them in terms of the drug testing you're going to do. Are we talking pre-employment? Are we talking, random or post-accident or reasonable suspicion only? And they need to understand, as I mentioned, the consequences. And they need to know sort of, what substances are going to be subject to being tested. In terms of the issue of random drug testing, and all I could say reminds me of that old TV show Lost in Space. I say danger, Will Robinson. There are some states where random drug testing is illegal. Under some circumstances in Massachusetts, random drug testing is okay and it can be legitimate. However, the advice that I would give to any employers is really be very careful and do it in consultation with employment counsel, so you know that you're doing it correctly and doing it right. If there is a challenge to a random drug testing policy or practice, the courts are going to review it on a case-by-case basis. And the balance will be the balance of the employee's right to privacy against the employer's interest in drug testing. And I think this gets to the point that you were making about, what is the reason for this? What is the legitimate reason for this? In terms of, you would only really want to be doing this in, really, really safety-sensitive positions where there is a real risk of liability, if employees are engaged in drug use. I would not encourage any employers to very lightly undertake a random drug testing. And one of the reasons why is that, that by engaging in random drug testing, there is the question about whether or not, just how random is it? And so there's an opportunity for some claims and liability for, disparate treatment of, whether it's, based on race or gender or other potential protected classes, exactly, how those random drug tests are being administered. The next level of drug testing is, post-accident and reasonable suspicion drug testing. And this is probably what, most employers do. And so how does that come about? And this is, some folks in the audience have already mentioned this, how is it that you have reasonable suspicion that someone is under the influence of drugs? And, and it could be, observations and complaints by, coworkers, clients, in the school setting, whether it's parents and students and things like that. And obviously, you need to get, the human resources and management involved in those circumstances when it happens. And as we often say in the employment context, whether it's, in the, for drug testing or performance reviews, documentation is key. So document. What to look for in terms of reasonable suspicion. Some of these things, there are some pretty, obvious signs that someone is under the influence of something, but other kinds of things that potentially could be looked at as change in mood and change in hygiene, appearance, etc. Absenteeism, obviously, accidents is something that might give rise to a question about that, and and how they interact with their coworkers. Observing and documenting the indicators. Generally, you're looking for, not just one sort of isolated incident or one isolated factor. You're looking sort of for, doing an investigation. I would use that word lightly, but basically, sort of tracking down and figuring out what the facts are and observing, the observable incidences to give rise to, whether or not we believe that someone is under the influence of drugs and need to instigate or initiate the testing thing. One of the things that you know, we and other employment lawyers suggest for employers is to, you know, have, you know, some training for their managers and have, you know, things like tools like checklists and things like that. You know, once you know, this level of suspicion is raised, you know, that's when you get sort of senior management, human resources involved, and your plan, you know, is put into place. This is not something, you know, that you as an employer want to sort of, you know, figure out once you're faced with the problem. You want to, you know, get ahead of it and know, how am I going to react if this situation arises. Again, you know, this is something that, you know, depending upon the size of the employer and the way that management is structured, could be challenging for a really small employer. But, you know, if possible, you want to get, you know, more than one person involved, and so that, you know, people can, you know, have more than one person kind of observing what the facts are that give rise to making the decision to send an employee to be drug tested. And then, you know, once you've determined that, yeah, there is reasonable suspicion here, we're going to take the step of, you know, asking this employee to submit to a drug test. Then, you know, you meet with the employee, you know, obviously in a private place, you know, so as to not, you know, embarrass them in front of their coworkers, or, you know, or cause, you know, any kind of discomfort in that. The meeting itself, you know, should involve, you know, obviously someone from management, the employee, obviously, and then, you know, another person, so that the employer has a record and a witness of what transpired. Explain to the employee, you know, what was observed and what's been documented, the reasons why the employer has made the decision to ask the employee to submit to a drug test, and explain that the reason why you're having the person submit to a drug test is because what you want to do is you want to rule out the possibility that they, you know, are in violation of the employer's anti-drug policy. And as a result of that, you know, you're asking the employee to submit to a drug test. And then, you know, as part of the policy that you should have a form where the employee, you know, agrees to submit to the testing. And again, that gets back to the point that I made before, that, you know, that agreement to submit to the test is, you know, is a condition of employment. But obviously, you still do need the employee's consent before you have them submit to the test. And this is key, that, I mean, that, you know, you obviously will also want to have, you know, a pre-existing relationship with a testing facility, and know where it is you're going to send them. And one thing, and this, you know, may seem like common sense, but, you know, employers don't always, you know, in the heat of an incident, don't always, you know, think rationally. But, you know, how are you going to get the employee to the drug testing facility? You're certainly not going to have them drive themselves. You probably don't want to have them, you know, call a family member or a friend to take them to the drug testing facility, because, you know, who knows what could happen in terms of, you know, tampering with samples and things like that. So, you know, either, you know, already have procedures in place, you know, car service you've got lined up, or a taxi and Uber, you know, as a last resort, you know, have management transport them. We don't necessarily recommend that because that just imposes a whole nother level of potential liability for the employer. When the employee is on the way to the testing facility, obviously the management will contact the testing facility to let them know that the employer is on the way. After the test happens, you know, what you would do with the employee is you're going to put the employee, you know, on leave while you wait for the results to come back. In the case of, you know, negative results, you know, obviously you will want to get that employee back to work as soon as possible, because, you know, while you had reasonable suspicion, there's obviously no reason to discipline that employee, so you want to get them back to work as soon as possible. Open question as to whether or not, you know, you want to pay the employee for the time that was missed while they were on leave. You know, that's a decision for the employer to make on a policy level. My first line response to that would be, you know, ideally I would recommend that you do have it be a paid leave for the employee while they're out pending the results of a drug test. In the case of a positive drug test, what are you going to do? Consider whether or not the employee continues to stay out on leave. You know, if you have an employee assistance program, which, you know, I think are great for employers, and I recommend them wholeheartedly. So a referral of the employee to the employee assistance program. You know, then consider what are the the conditions upon which that employee will return to work. There used to be these things, that we used to refer to as last chance agreements, where, okay, you sort of this sort of kind of one strike and you're out sort of situation, where, basically getting the employee to agree that, if this ever happens again, you're going to be terminated. Those are sort of, carry some risks, and they're sort of less favorable, and rather than, having kind of this sort of last chance agreement, look more at a sort of a holistic kind of return to work plan that takes into account, what the, if there's a treatment program or, or some other circumstance, and sort of not be so prescriptive in terms of, these sort of hard line, last chance. And then, really the bottom line is, and again, this is, have a policy, know what the policy is, be prepared for it, and then obviously follow your policy. And so, which, is a lot of employers don't always do that, and that's really kind of the reason why you have the policy in the first place. So make sure you follow that. So that's kind of a whirlwind tour of reasonable suspicion drug testing. If anyone's interested, I could get you some more information about that, but just kind of wanted to spin through that pretty quickly before we move on to the next topic.
So, and we're just going to spin in our final few minutes together just a few highlights for you in terms of what's going on in the primarily the K through 12 school space, which is really my area of expertise. I do some work with higher ed, but so in terms of what's going on in schools, and frankly, not much has changed. Even with all the new landscape we're in here with legal use of marijuana in Massachusetts, it's still not permitted on certainly K through 12 campuses, I think, and it's, you need to be 21 or older to consume, at least recreationally. Minors who have the serious medical conditions that we talked about before, certainly instances where they may be approved for medical use marijuana. But and it can certainly be a little bit more complicated on colleges and universities where some students will be over 21. But I bring us back to the accommodations issues we talked about at the beginning of our talk with you, and the Barbudo case. That will apply to schools. Schools, after all, are also employers, and it may also apply to students in addition to employees at school campuses. So what we would say is, that case does not stand for the fact that you have to permit use of medical marijuana on a school campus, but it does indicate that you really should engage in what is called this interactive process. So you don't want to just shut it down if someone comes to you and says, I have a legitimate reason to be using medical marijuana, but you want to, engage in that back and forth dialogue and figure out, is there some way to accommodate that use? It would be off a school campus, but again, you want to be open to that dialogue. Let's see. So if you do wind up with someone, so make sure I'm on the right slide. This use comes up on a school campus. How are you going to address it? And we work with a lot of schools in New Hampshire, where New Hampshire has a very comprehensive safe school zone law, which outlaws all sorts of crimes, in addition to possession of drugs and alcohol, assaults, that kind of thing. And a lot of our school clients in New Hampshire enter into MOUs with local police departments to address how they're going to deal with the fact if a student is caught with a joint or a vape that contains a cannabis product, something like that. These small personal use amounts of marijuana. So we would, many of our clients, for good reasons and bad, also have relationships with local police. So we certainly encourage them to open up that dialogue with law enforcement. What are we going to do if we, bust some kids with small amounts of marijuana? We have heard actually from our clients tell us that the police, look, we don't want anything to do with a couple of joints or, a jewel or, you deal with it. We're not, we've got bigger fish to fry in our police departments, just deal with this as a school discipline issue. So if that's, the information you're getting from law enforcement, just make sure, you've got a policy with how you're going to dispose of that substance. Make sure you document how you've done that. So that's the kind of some of the questions we're getting from our school clients around how to deal with personal personal use amounts that might show up on campuses, employees or students. On the parental rights piece, I'm not going to read this very dense slide, but the one point that I wanted to make here is that marijuana use alone, now in this landscape, is certainly not a reason to discuss people being bad parents or engaging with the foster care system, their child welfare system, that kind of thing. So I just want to highlight that. I have not yet had a school question me about parents who were using cannabis, and the school was concerned about, perhaps neglect. I did have a school counselor call me last year about concerns that a parent was overusing Benadryl. So the student came in and was very concerned that mom was, I think there was a stressful divorce, and mom seemed to be over-medicating with Benadryl. So we did have a long conversation about whether or not that was worth a call to DCF, to the Department of Children and Families. I think ultimately the counselor decided he did need to report that. I don't think DCF wound up substantiating that case. But so that's probably the closest I've come to dealing with the question of parental use of cannabis was Benadryl. But I'm sure in the coming year or so we'll start getting some questions about that. And then just finally, some drafting tips in terms of going back to the handbooks for both students and employees. We find drugs and alcohol, lots of different catchphrases for how drugs are captured. So we just like to be, I was an English major before I was a lawyer, so, I'm sort of therefore a double or triple threat when it comes to, careful drafting. So I always kind of hone in terms of, making sure we're careful with how those policies are drafted, just to make sure we're reinforcing that even though, the law of the land now permits recreational use, that's still not really permitted on our school campuses. We put in the boats, many of our clients are, bigger schools on more rural campuses. They may have water features on their campuses like ponds and lakes and canoe programs and all those kinds of things. And even, if a boat is not motorized, it's still not permitted there. So just to reinforce that, if, some of the juniors think it's a good idea after dark to take canoe out on the lake and bring a jewel with them and have a good time, that we're making sure that school policies are really comprehensive in terms of ensuring prohibitions for especially young people on campus. So I think that actually lines us up.
Do we have some time for a couple of questions? Does anyone have any questions or comments or things that they are dealing with? The one thing I would just like to go back just very briefly to the issue of drug testing and drug testing policies, and and I think that just to make the point that I probably could have made clearer before was that I think that because of what has gone on in the last 10 years in terms of decriminalization and legalization of marijuana, is that employers I think really are starting to and need to move away from kind of the sort of blanket drug testing and drug policies and really do, and this is just good planning no matter what for any kind of policy, is to make your policies to be job related and think about what is it that you are either required by law to do and what is job related. So whereas employers in the past would just have sort of these blanket either pre-employment drug testing things, think about, do I really need to do drug testing on, my receptionist or, or things like that, whereas, is there a job related reason? And, and that's just, whether it's in the area of drug testing or really any kind of employment related issue, if you can make your decision and your criteria to be, job related, that's only going to be to the employer's benefit in protecting the employer against a claim of some kind of discrimination or violation of some rights. So that's kind of the thing that I would, leave you with. I mean, and unfortunately, I think that until we have some more clarity and some more help, either from the federal government in terms of the legality issue, and then from science in terms of providing us with some way to test for whether or not someone is actively currently under the influence, employers are still going to have these challenges of kind of bumping up against different things and dealing with difficult situations. And really, that's and that's why you have really good human resources people who are professional and know what they're doing and have the phone number of an employment lawyer who can help them out. And so I think that employers need to be, thinking about these things in a thoughtful and careful way, which I know most employers, want to do that. So that's kind of, what I would leave you with.
And along those lines, given the difficulty in testing for impairment, and given the presence of equivalent of impairment for things like sleep deprivation or distraction from phones, do you see employers moving away from drug tests and moving towards kind of a zero tolerance policy towards actual conduct? Saying, look, if you crash the forklift, you don't care if you're high or you're tired, you're still fired.
I'm not seeing that, and I think that part of the challenge is, just sort of, hearing that my initial reaction to that, a challenge with that, again, goes to the causation piece of it. I mean, in terms of, it's one thing to be able to, if you have someone who, crashes the forklift and they take a breathalyzer test and say that they currently have a blood alcohol, level of X, say, well, there's a pretty good causal connection between that. But, when you get into issues of, other sorts of causes of what might make someone, be irresponsible at work, it's going to be harder to sort of, pinpoint that and say, is it really the employee's fault? And I also am just sort of, issue spotting here, thinking about some other things in terms of, some of those things, the sleep deprivation piece of it, is that, something that, is that really the employer's fault? When you think about, people who work long hours and things like that. So it's an interesting issue, and I don't know what the answer is, but I'm certainly not seeing that happening already.
And I'll just quickly add, the term zero tolerance has fallen, in the school context certainly, has fallen a bit out of favor. Back to the sort of social justice piece in terms of school discipline, this isn't really a bit off topic in terms of just about marijuana, but those types of policies were disproportionately affecting African American students, young men in particular, kind of that one strike and you're out. So I would say we are also, just in terms of policy drafting, whether it's employment or in school policy, like that last chance agreement, right? It's sort of a zero tolerance kind of concept, and I think there's sort of this notion of moving away from that concept in general.
Are you aware of any pending litigation in the Superior Court or elsewhere that touches on any of these issues? Is there anything kind of working its way up?
There's not. I mean, in terms of, things, my source for all these stuff is usually Mass Lawyers Weekly. I kind of, but the Barbudo case was a big deal. But in terms of that, I have not heard of anything kind of percolating, that's, kind of that sort of same level. And again, and also on the legislative front, again, all these laws that I've mentioned, these bills, they're sort of kind of currently parked in committee, and I don't know that there's a huge amount of groundswell to push them through. So I wouldn't even really tell you what's going to happen with those.
And just a second bit of that that's unrelated, apart from the litigation element of this, is there any science out there that you're aware of that seeks to answer the question of whether and like what level of marijuana someone needs to have in their system to be impaired, and how does impairment function, with that drug? I mean, it's clearly, I would say, obvious that different drugs create a different sort of impairment, and they impair different things in different ways. Are there any science out there being conducted that you're aware of on that point?
Not that I'm aware of, but I think that part of the problem, at least, and then I just know this from what I've read in news coverage about it, but in the same way with regard to because it's been a class 1 substance, that there's been not a lot of research done on it, and so that's been a challenge in terms of the medical applications of it, where there's not been a lot of real clinical research done on proving how it's beneficial. And my suspicion is that kind of research that you're talking about has probably been lagging as well. And that's an unfortunate thing, and it's a complaint that I've heard, again, in the media from law enforcement about sort of this frustration of, the culture and the laws are moving, at sort of light speed in terms of, providing for legalization, but then, the police officers don't have, you know, the same tools that they have to deal with someone who is suspected of being under the influence of alcohol. They don't have those tools yet when they're, you know, when they're dealing with, you know, someone who potentially is impaired. So, so I'm not aware of that science going on.
And sorry for just maybe kind of hogging this a little bit, but are you aware of any OUI type cases that have come up through the criminal system where there has been an allegation the person is impaired under marijuana, and that works its way somewhere through the criminal system, you know, at some point? Have you, even people being charged with OUI for marijuana? I know it's not your core area.
Right, yeah,
Yeah,
but I have, but we might have a
There's a ton of them, I can talk to you after this.
yeah.
Trooper Clardy was killed in a car accident by an alleged impaired operator that just left a medical dispensary and it smoked. So there's numerous technology things that are coming down the pipeline that they're trying to get out there. There's numerous cases. OUI narcotics is incredibly hard to prove because you don't have the testing mechanisms in place, like a field sobriety test. Those are scientifically proven. So the testing on the roadside is not scientifically proven. The field sobriety, the breathalyzer test, again, that's scientifically proven. You can articulate why the blood alcohol concentration, we can't do that with the marijuana. We can show that the marijuana exists in your system, but we can't show when you add it in your system.
Yeah, I'd be curious to talk to you about that and to how the courts deal with that, you know, how they perceive that, because there's a lot of tricky issues you just mentioned.
Oh, okay. Yeah, I've been made a fool of a couple times.
Thank you very much.
Thank you.